Afternoon, everyone. And on behalf of the RegTech Supercluster, I'm delighted to invite or welcome you all to this event. Just a minor technical matter at the start. Your screen might now be showing a serious number of tiles with just initials on them. If you want to focus in on the speakers who are speaking at the time, you might want to go to the view icon at the top of your screen and convert it from gallery to speaker. But it's a matter for yourselves. A close-up view of some of us mightn't be what you want either, but just sometimes a very bland screen if you have an awful lot of tiles on it. So again, a really warm welcome to everyone. I'm Brona Heverin, and I'm the Head of Department of Law, Public Service and Education in the Atlantic Technological University, easily known as the ATU, and I'm going to be the MC for today's event. So as you all know, the theme for today's event is the new EU Digital Operation Resilience Act, which came into application for many financial entities last January. That's quite a handful in terms of a title. So for ease of reference going forward, I'm going to call it DORA, which is a lovely, friendly acronym, and I imagine most of the presenters will do likewise. We have a wonderful lineup of presenters who you can see on your screen, and I'm really delighted to welcome them here today and to thank them for giving their time. We really appreciate it. So a great big thank you to all of our presenters and those involved in the panel discussion. So in terms of format, we're going to begin with the presentation from Darren Connolly from the Central Bank of Ireland. And then we're going to have a discussion involving a panel of experts who you can see on your screen. We have Paula Kennedy Garcia, who's a global outsourcing expert and former CEO of Forward Emphasis here in the Northwest. It's great to see you. We have Luke Scanlon, who is head of fintech propositions for the international law firm Pinsent Masons LLP based in London. Again, another lawyer. Great to have you here, Luke. And lastly, we have somebody who's at the coalface. We've Mark Hughes, who's managing consultant at First Derivatives, where they're currently working on DORA implementation. So we'll come back to all of those in greater detail later, but just to give you a heads up. So we'll have the presentation by Darren followed by a discussion. And in that discussion, we'll try to digest and analyse much of what Darren says. In particular, the practical and real implications for everybody affected by DORA. So finally, before we begin, two small housekeeping matters. This is being recorded. And to be fair, none of you are participants apart from the presenters, so it won't affect you in that way. We're not looking for consent or anything, but just to let you know, the recording will be available on our website after the event if you want to share it or review it. Secondly, we have a question and answers function open there along the side. And if you have any questions as the webinar progresses, please feel free to upload them there. Hopefully, most of them will be addressed in the course of the discussions, but if not, we'll try to address before the end, and failing that, we'll take them on board and maybe use them for potential future webinars if there's something of real interest in them. So please feel free to contribute to that. So before we begin, I'm going to now hand you over to Anne-Marie Conlon, who is Head of Economic Development in Donegal County Council and a foundation member of our RegTech Supercluster. So Anne-Marie is going to begin by giving you an overview of it on behalf of all the partners. So thank you very much, Anne-Marie. I'll hand it over to you.
Thank you. Thanks very much, Brona. Again, just for a few minutes, I just wanted to tell the audience a little bit about the RegTech Supercluster, and I'm delighted to be here today speaking on behalf of the Supercluster and on behalf of our partners and our other partners as part of this initiative, along with Donegal County Council, our Derry City and Strabane District Council, Ulster University, Atlantic Technological University, also known as the ATU, Catalyst and Alpha Innovation. So, and our aim in terms of the supercluster, our aim is to bring together industry, regulators, academia, and the public sector, working across sectors and working across borders to become the world's first multi-sector RegTech supercluster. Our feasibility assessment, which was supported by the Shared Island, demonstrated a compelling case for establishing a supercluster here. And that's really around given our unique location, which straddles the EU and UK border, and the cross-jurisdictional talent pool that we currently have in this region. Our partners are now working towards securing additional funding to realise the full ambition of this project. And to date, we've been quite busy and we've done quite a lot of work. We've hosted a national conference, we've hosted hackathons, and we've hosted other events. And we're currently scoping out an innovation challenge in partnership with the City of London, as well as looking at a similar challenge in the medtech space. And this today is the first of a number of series. It's a new series of webinars that we're planning to host over the coming period. And it's really around raising awareness and exploring key issues around the whole area of regulation and innovation. And for details on future events, I would like to invite you all to follow us on LinkedIn or sign up for notifications on our website, which is www.regtechsupercluster.com. And we're also really keen to hear your own ideas in terms of themes. I think just as Brona mentioned there, themes or ideas for future seminars and future events, and maybe focusing on maybe particular pain points or particular issues that you're finding in terms of your own space, and how those could be explored through a forum such as the RegTech Supercluster. So I'm going to leave it at that, and I hope you enjoy the webinar, and I'm certainly looking forward to hearing more from Darren and the Central Bank of Ireland, and indeed all our industry panels. So good luck with the webinar, and I look forward to hearing more on it. Thanks very much, folks.
Cheers, Anne-Marie, and thank you very much for a clear and comprehensive outline of what the RegTech Supercluster involves and its importance. And as Anne-Marie had said, we'd be very happy to have more people involved in it. So if you're interested, there's the LinkedIn page and the website. Please feel free to make contact. But so you're not here to hear all about that, you're much more importantly, we want to hear about the focus of the webinar, the Digital Operation Resilience Act, or DORA. So I'm very happy to welcome Darren Connolly, Senior Policy Specialist at the Central Bank of Ireland, to make his presentation. The last few days have been a really resonant reminder of the necessity for stability in all of our systems. And this is particularly true for our financial systems, where the central bank is tasked with protecting. And the focus of this piece of legislation is to ensure greater stability and resilience. And I'm not the expert, but I can see from the outside that this is a really important piece of legislation. Darren is a particularly, I suppose, useful exponent to have in relation to this legislation because he's been involved in the development of the European DORA regulations and contributed as a member of the Joint European Supervising Authorities Working Group who developed the technical standards relating to ICT risk management and incident management and reporting. But he's not just part of the regulatory side, and I think that gives greater depth to what he's about to say. He's a great breadth of experience prior to his role in the central bank, working as a senior IT risk and inspection specialist, a bit hard to say that, and over the past 20 years has worked in various areas of IT services, including software programming, infrastructure and network engineering, program management, audit and service delivery at global IT outsourcing providers, primarily with clients in the Ireland and the UK. And it's lovely to see that depth of experience moving to the regulator side, and you hope that that will be reflected in the nature of the regulations we get, very real and applicable. So without further words from me, can I extend a very warm welcome to Darren and hand all over to you if you now would like to share your presentation, Darren, and begin.
Thank you very much, Brona. Fabulous introduction there. And to Anne-Marie for the lovely opening as well in the background. Could you just confirm you can see my screen okay there before I proceed?
Yes, it's coming up very clear. Thanks, Darren.
Great, excellent, thank you. Again, thank you to you, the panelists, the Northwest Supercluster as well for inviting me along, and indeed to everybody who's attending today. Obviously, I've been deeply involved with some of the developments of the DORA regulations over the last few years, and I do see its importance, and I'm quite keen to see it land successfully. So I'm delighted to have the opportunity to talk with you all today. I understand there is a mixed group in terms of knowledge of DORA, so I'm going to take it from first principles and maybe focus on some things I learned on the path, and hopefully there's something for everybody to take away from the presentation. So without further ado, the first question is why does DORA exist, the Digital Operation Resilience Act? Well, there's nobody in the room who would argue that technology continues to advance at a stunning pace. It's brought a lot of benefits and clear impacts in how society functions, but certainly in the financial system. Everybody can see the change in the way people pay for things recently. Algos in trading systems, and yeah, even AI as that starts to take hold. But as a result or accompanying those benefits, it also introduces a number of risks. And it's that very increased digitalization and interconnectedness that does mean that when a risk occurs, it can propagate really quickly and to a much wider extent than previously. The European Systemic Risk Board a few years ago specifically identified cyber as a potential source of a systemic risk to the financial system. And the legislature, that's the Commission, the Parliament and the Council, responded with the European regulation. Now, the choice of a regulation in Europe, you've regulations agreed at the European level, which are directly applicable in each country. You've also got directives, which come into force in national law through national transposition. And then you have national rules. And what had happened in the absence, after the financial crash, the regulators, Europe was great to come out with lots of rules for the financial system on capital and liquidity, ensuring that firms, were well financed and prudently managed from a financial resilience point of view. But there was a gap in terms of, that same operational level resilience. And in that vacuum, a number of nations stepped forward with their own regulations. And what we saw is quite a fragmented landscape. So DORA, it was chosen to use a regulation. So this would apply everywhere across Europe in a harmonized manner in order to raise the overall level of the financial system. And I also hope by using that single instrument that a lot of the requirements of DORA become standards going forward and make it easier for firms to meet that standard. What I'll say now is, who is involved in the development? The legislature I mentioned at the top is the Parliament, the Commission and the Council, who together developed the regulation. But once the regulation was developed, it actually came into force in January 2023. It was published in December 2022 and came into force shortly after that. But there was a 2-year gap before it came into application for financial entities in scope. The reason for that 2-year gap was that there were a number of technical standards, regulatory technical standards and implementing technical standards which were needed. Those are known as delegated regulations because the legislature delegate them to the Commission to adopt, and they were actually developed by the 3 European supervisory authorities, who are the Banking Authority, the European Banking Authority, the Insurance and Occupational Pensions Authority, and the Security Markets Authority, which are there in the second bubble. So they, through their joint committee and supported by about 40 competent authorities, that's financial authorities from the different member states. And bear in mind, in the Republic, we have an integrated regulator here where we do central banking, where we cover, banking, credit institutions, payments, markets and insurance all under the one authority. In other countries, they're often separate authorities. So it was quite a large group of people involved to negotiate these. ENISA, which are the European Cybersecurity Authority, the Systemic Risk Board I mentioned, and the Single Resolution Board, and of course the European Central Bank, who also do the direct supervision of the significant institutions, the largest banks in Europe. So what does it involve? There's a regulation, there's an amending directive. That amending directive, it's quite straightforward. There's only 9 articles in it, and what that does, it amends existing financial sector regulations to make sure they align with DORA. So the likes of MiFID II, Markets and Financial Instruments, the Payment Services Directive, which previously had its own incident reporting, the CRD, multiple regulations across the 3 sectors were impacted minorly to align with DORA. And basically, when you're applying those regulations now, if you're considering network or information systems, they have to be aligned with DORA. There were a number of guidelines developed. Statutory instruments were needed in Ireland. That's for the amending directive and also to implement some of the member state discretions and choices in DORA. There were 2 statutory instruments produced. One is the amending statutory instrument, which amends the existing directives that were impacted by DORA. And the other one was on those member state discretions, including the decision to apply DORA to credit unions only from January 2028. One very useful other item to note is if you look at the ENISA site, they've actually put together a landscape of regulation, and DORA doesn't exist in isolation. The European Union has been tackling this on many fronts, and I just found that was an excellent graphic readily available on the ENISA site to see how this fits together. One regulation of note there is NIS 2, which is the Network and Information Security Directive, and that sets requirements on cybersecurity for those entities that are important or essential to the functioning of the states, energy, water, etc. But specifically, the way the legislation was designed is DORA acts as lex specialis for NIS 2. So for financial entities, if they comply with DORA, they're considered to have complied with the relevant requirements in NIS 2. So that's the exciting bit on legislation. Moving on to who it actually affects. Basically, all the small bubbles there are types of financial entity identified as by DORA as being in scope. If you look at Articles 2 and 3 of DORA, it tells you the scope of application, but you need to consider the definitions of what's meant in those scope statements. But essentially, it follows along the lines of existing sectoral regulations. For instance, payment institutions and account information service providers, it generally follows along the lines of those entities which under the Payment Services Directive, electronic money institutions under the Electronic Money Institution Directive, the crypto asset service providers, that's under the new MiCAR or Markets and Crypto Assets Regulation. So it follows generally along the lines of their authorization. So generally, if we've authorized one of those financial entity types in blue, and by we I mean the Central Bank of Ireland, they're generally in scope of DORA. For insurance intermediaries, there is also size thresholds, so some are out of scope. And for some entity types, not necessarily based on size, but for instance, for small non-interconnected investment firms, there are some simplified requirements within DORA for those. There are other types of entities which aren't currently, they're either supervised by European authorities directly or they're not present in the state but do exist in Europe, are represented in the grey boxes. There's one other authority in Ireland which also has entities which are subject to DORA, and that's the Pensions Authority for IRPs, institutions for occupational pensions. And brand new, if you see the pink box on the right there, it mentions critical third-party service providers. This is something brand new and quite novel in DORA, and you will see that the UK has taken moves as well to look at critical providers in Europe, in the UK. But what this is DORA is going to require the European supervisory authorities to identify those ICT third-party service providers, ICT, information and communications technologies, third-party service providers that are critical to Europe, and they're going to directly oversee them. And you might ask why, and very clearly, we have a number of big players in Europe that large segments of the financial system are heavily reliant on. In many ways, they act as if they're utilities, but they're not actually regulated at all in terms of supporting the financial system, those specific operations. So the intention here is to get insight into the risks and the measures they're taking within their systems so that financial entities can make appropriate decisions on their use and understand the risks that are involved in using them. So that is very novel, very new. Only ESMA have done direct supervision before. The EBA and IOPA have not. So that's quite a new activity. So what are the key elements of DORA? Well, yeah, this is our DORA house. If you actually look at the DORA regulation, and you'll find it on Eurolex, the official journal of the EU. If you Google that and type EU 2022-2554, you'll bring up the regulation. And if you look at the title of the different articles in DORA and the chapters, what you see there are essentially the chapter titles. But each article certainly should make sense as to what the title of each article on its own should make sense as to what it's trying to tackle. Chapter 2 is on ICT risk management, and that's requiring financial entities to have, an appropriate risk management framework so that they can identify and manage the risks that the financial entity faces by virtue of using the IT. The chapter 2, it covers things like the governance and organization, the need for the specific risk management framework itself, requirements on on having appropriate systems, protocols, and tools that have enough performance and capacity. There's articles on identification, protection, detection, response, and recovery. Many will know those concepts from existing standards, and as you read DORA, you will see those. It has been based on existing sectoral and international good practices. There's an article on having backup policies, procedures, and actually testing your response and recovery plans, including considering of severe but plausible scenarios as to what can happen. Really important is an article on learning and evolving, and on crisis communication. This is the most meaty chapter of all of DORA, and it's accompanied by a regulatory technical standard further specifying the requirements around the systems, procedures, and tools, and for instance, requirements on encryption, key management, asset management, change management, all those areas which introduce specific risks into operations. So it's really key that if you're looking at that chapter, that you consider it with the regulatory technical standard that accompanies. And what you'll see is it's actually quite challenging. DORA, it isn't a set of rules that you just do and say, I'm DORAfied, we're done forever. The intention, because technology is constantly changing as well, and the external threat environment is changing, we're seeing growing cyber threats. DORA tries to be principle-based and relatively technologically neutral. So it's putting requirements that, like on the identification, the first thing, and it's actually really challenging to do well, is that, financial entities, first of all, need to understand what their own business functions are, what their dependence is on information and ICT assets in the delivery of those functions, and then how they relate to the risks for the financial entity itself. That's Article 8.1. That there is actually a lot in that. If anyone's ever tried to put together a comprehensive configuration management database so that they can track the interconnectivity of the various network and information systems they use down through the stack, it is quite challenging. But it is absolutely key. You can't actually manage what you don't know. On the governance, there's also some key requirements, to put clear responsibility on the board, that it's not okay if you have a financial entity to just say, I don't know anything about, digital operations or IT risk. And in fact, there's requirements on the skills of the board to be kept up to date, so that they can actually understand the risks that they're exposed to. I'll move on to the next chapter. And yeah, mindful of time, I think I have about 5 minutes, Brona. I'll keep trucking. The other chapters are a little simpler. There's one other item I want to mention in the risk management. On an annual basis, financial entities need to do a self-assessment of their risk management framework. And there's actually a specification at the end of the regulatory technical standard on it's further specifying the tools and processes for that risk management framework, which sets out what's expected to be in that. And it starts off with, I'm really hopeful that'll be a useful document to simplify the conversation between regulators and firms. And we've seen examples in the past own risk solvency assessments in insurance, where firms, make their own risk assessment, and that's a starting point for the conversation with the regulator. So that report, it starts off, even in the introductory section, it gives the firm an opportunity to say who they are, what their systems are, their dependence on IT and third-party providers, and what they see as their actual risk posture in relation to, operational incidents and cybersecurity. That's something that will only be done. We haven't seen it done yet. It'll be done for the first time this year because it's an annual requirement. But it's an area where I think it can simplify the conversation, as I said, between regulators and firms, and also I think will be a key document for management bodies to understand their operations further, or to assess and manage that further. In terms of incident management, there's requirements to be able to manage incidents. But DORA specifically introduces reporting requirements. So if you have a major ICT related incident, there's specific thresholds to assess when it's major or not that are specified in an RTS with the classification criteria. And then there's a further RTS and ITS giving the timelines and the content for the report you have to do. But essentially, and in order to act as lex specialis of NIS2, my apologies, easy for me to say, it also has to meet the same type of timeline. So there's an initial report. If you have an incident, you need to notify the regulator within 4 hours of classifying the incident, within 24 hours of the firm first becoming aware of it, in any case. And that incident will then be forwarded on to the appropriate European supervisory authority. Now, that does a couple of things. There's also, an intermediate and final report there. That is intended to do a couple of things. First, and primarily, is if we do get a systemic issue happening in Europe, that we at least become aware of it, and can take some measures on the back of that. Also, the ESAs are going to produce an annual report, and I know it can be hard to get objective information on the level of or types of incidents that are actually occurring out in the wild. So hopefully that'll be very useful. But as I said, the key thing is if a systemic issue occurs, that we can respond quickly. I'll move on very quickly, Bron. I know where I am. On digital operation resilience testing is the next chapter, and that obviously it looks for proportionate testing. We're talking about vulnerability scans, pen tests, end-to-end testing, code reviews as appropriate to be done, but also introduces advanced threat-led penetration testing, which is similar to our existing Tiber EU framework, or Tiber IE in this country, which is threat intelligence-based testing, and in the UK be somewhat similar to the UK CBEST framework. But the idea there is it's only for the most important financial entities in the system in terms of potential systemic impact. But if you're one of those, you're expected to do an advanced red team test every 3 years, with the competent authorities taking part. So that's to enhance the resilience and the cyber defenses of those most important entities within the financial system. Finally, I'll move on to managing ICT third-party risk. This is big and quite impactful. There are significant requirements in terms of key contractual requirements, ensuring firms only contract with providers who will meet those requirements. They need a strategy on a third-party risk strategy as well. And I think as DORA has gone live, this now requires financial entities to look. It's not enough to contract with an IT provider who just says, I'll give you this service, but don't ask me about it. You need to know where your data is going, who's processing it, who's accessing it, who their subcontractors are as well. So there's actually been quite a lot of work, I believe, generated in getting those contracts to a level where they can, that can be ensured. And in fact, in order to set up the oversight framework, the ESAs have required us to collect a copy of the registers of the ICT third-party providers for all the financial entities, so that they can identify who the critical third parties are and set up their oversight framework. There's also one short chapter about cyber threat intelligence sharing and information sharing. I shall move on nearly there, Brona. So just as to where we are, obviously you had the regulation development first. We then have had 2 years of preparing the additional technical standards and for financial entities to prepare themselves. We're now at that point in April 2025, where DORA has come into application since 17th of January. Right now, we're performing the very first collection of the registers of all those ICT third-party providers that financial entities rely on, which hopefully will be very useful in identifying things like concentration risks in the system. And indeed those critical third-party providers. The first round of the advanced threat-led penetration testing I mentioned will start later in the year once that technical standard is finalised. And once the ESAs have the information from those registers, the critical third parties for Europe will be designated and the oversight will start. Lastly, and I am just at the end, Brona, my apologies, I have run over. I did want to note that in February, the Central Bank of Ireland published its regulatory and supervisory outlook report. And if you look at that, you'll very clearly see that we see operational risks and resilience as being severe with an outlook as increasing. And the reason that's been identified is we still see increasing reliance on third parties, growing incidents and sophistication of cyber attacks. In certain cases, there are still some legacy systems which are still undergoing a digital transformation. Generally, the operating environment is becoming more complex. Interconnections, dependencies, as I mentioned, often amplifying issues. And the users of the system, 24/7 access is now expected on most systems. So in an environment, and that's without going into geopolitical and other environmental changes going on, this remains to be an area of significant focus for us. And Brona, I'll leave it at that. Should say there's a few references at the end if you want to share them with the audience.
That's great, Darren. And to be fair to you, it's no easy task to try to summarise DORA in just a few moments. And to be fair to the regulators, it's a very complex area, so the legislation is going to be similarly complicated. But certainly you've given us a very good foundation for having a discussion on the implications of it. So thanks a million for that, Darren. It's a great start. Now, some would argue that drafting the regulations is the easy part. It's when they come to application and implementation, and more importantly, compliance, that the real challenges arise. So we've got a great, I suppose, variety in our panel contributors now who are going to look at DORA from the perspective of dealing with it there, whereas I say many would think it's a harder part. So for a first question for each of the panelists, and to, I suppose, enlighten everybody who's listening, what their particular perspective is, I'm just going to ask each of the panelists, where they're coming from and how DORA affects or is affecting their work on a day-to-day basis now. So I'll start off with ladies first. Paula, I'll go to you first if you don't mind.
Sure. I guess, so I come from global BPO, business process outsourcing. So I guess, to Darren's point, I'm bringing that day-to-day perspective of the ICT as a third and fourth party risk. So an outsourcer in itself will be that third party, but actually it can have a ripple effect on through to fourth, fifth party risk, depending on how sophisticated systems and technical solutions that you're offering out to your clients can be. So, from our perspective, whether that's an incredibly large organization or a small organization, there will be a level of solution that is in there for every organization that they service, and they need to ensure that the accountability around the stability and the reportability of all of that is in place.
No, a very onerous undertaking. I mean, even to think about it sounds onerous. So to actually, to put all those processes and records in place sounds really onerous. But they'll need guidance for that, and they'll go to the lawyers, or at least a lot of them will, hopefully, Luke, in the first instance. So you're coming from the legal perspective on it. How has it, again, if you wouldn't mind outlining to our audience your role and how DORA affects the work you're doing at the moment?
Yeah, sure. So I've been involved in DORA from the start, advising clients around the policy stage, so the consultations and positions they could take in relation to the law, right through to its implementation now. So focusing on remediation projects, as Darren mentioned, the third-party risk side of it. So for financial institutions, helping them understand what needs to go into their contracts with third-party providers. I'm also acting for some third-party providers, some of the largest ones, which would become, or they expect to be, ICT critical third parties going forward. So they need to understand the requirements that will apply to them specifically, but then also their subcontracting arrangements and that third and fourth party risk issues and understanding, how that all comes together. And as Darren mentioned before, just understanding how it all actually works, the technology right through the chain and where the risk is. So there's a lot there, and all the advisory bits around classifying, etc.
Yeah, you won't be short of work is what I would gather from that. And then turning to you, Mark, you're I suppose more at the cold face in terms of trying to put these processes and procedures in place to ensure adherence. So would you mind describing where you're coming from and again how it's impacted your work so far?
Yeah, so I'm a managing consultant at First Derivatives, working in our reg solutions practice. I'm a project manager primarily, and my job is really helping our clients with their regulatory obligations. So like I'm currently working on the DORA implementation for a global bank, and my area of focus there has been on the Register of Information. So I've been working with our banks, inter-affiliate and third-party teams to gather all the contractual arrangements to be reported, helping to identify the bank's critical and important functions and the third-party vendors that support these. I've also been involved with our tech and automation teams to help build the register. It's a large amount of data and it's coming from multiple sources in the bank. So I've been involved in drafting requirements, getting approvals and decisions from the business, bringing the register to our board members and senior management for sign-off. And recently, a lot of my work has actually been on the testing and validation of the register ahead of the submission this month. So I've been doing a lot of validation on the ECB Casper portal of the register ahead of submission. So,
and that's actually a great place to start, Marcus. I'm going to stay with you because that's the most imminent deadline in terms of, the first collection of the DORA registers of information. So you're in the process of preparing a submission for that. So I suppose, in a very practical level, how have you found the operation of the Act in terms of what you have been required to do and how, well, I won't say the word easy, but has it been easy to achieve, to put this register together, or what kind of an undertaking has it presented?
It's been challenging. Like the DORA, it's a large the bank systems they're very complex in nature, very interconnected and complex sources of data. It's complex mesh of systems, and the regulation itself, it's a large piece of literature. Combining this with updates to the technical standards along the way, it has been a challenge to get in motion. So ahead of the submission this month.
No, fair, and I would imagine that that's what it will present to most businesses. Like, they will be not frightened by it, but they'll certainly be, realizing the necessity, I would think, Luke, to be coming to the lawyers. I don't know if they have been, but this move from guidelines to regulation, is scary for a lot of businesses because guidelines are all very well and most will try to adhere to them. But once it's a regulation, there's no choice about it. How have the practicalities changed for you since January when this has come into effect?
Yeah, so it's been interesting. If we look back on the last few years, and as you mentioned, guidelines, but the EBA outsourcing guidelines were very strong expectations. So most of our clients would put those in place, but they had a 2-year window after the guidelines were available to put them in place. About a year ago, we expected most clients to be moving. The concern was, though, some of those regulatory technical standards weren't finalised, particularly the ones around subcontracting, hadn't been finalised until after the January deadline this year. So that's meant that, some have done work. Some thought, do we go DORA 1 and DORA 2, make some changes, make a second lot of changes? But of course, that's cost in itself and effort. Some have waited. So there's been different approaches taken across the sector. We're starting to see that come to an end because, it's reasonably clear what all the requirements are now. So there is a lot of movement and push at the moment, but we're still in the midst of it. I would say most are thinking about prioritization. So what's critical? Do that first, then think about what else needs to be done, expecting that the regulators will also take that approach.
And I'll come back to you, Darren, in a second to see how you feel about that approach. But I think you're right. I think deadlines force the mind, and that those are the things that they're going to have to adhere to in the first instance. But I think one of the, I suppose, most pressing concerns is that whole chain of contractors. And Paula, would you have an oversight of that in terms of a lot of that would be it arises because of the tendency to outsource? So, how has DORA impacted all of those connections and transactions?
I think so. I think, Darren, you touched on it. Outsourcing the services that support your business is increasing for many reasons, cost-driven, efficiency-driven, just getting that group of people who can be closest to the most emerging tech that's coming. So that's going to be something that continues to increase. And that increasing sophistication and solution is where the real trouble comes. So I'm not surprised to hear what Mark and Luke both say in terms of being, a challenge in getting that first data gathering together. But I guess they're also taking it from the perspective of dealing directly, primarily with those financial institutions. If I come into the back end from what that means as a third party in the mix, listen, the practical impact is primarily resource related when it comes further down the stream. The new regulation, everybody is learning and getting ready to be compliant at the same time. And as we know, when those deadlines do start to loom, then that same time surge in demand for regulator returns and later down the line for audit ready data, puts pressure. It'll put a strain on any organization. It'll be more pressing for smaller companies who just may not have the luxury or might not have invested in a dedicated compliance function, for an example, or have owners in their business that probably double hat. And so you've potentially got unqualified people across the business doing their best to complete all of these returns at the same time to the various clients that they do. And I liken it sometimes to that Spider-Man, the 3 Spider-Man meme that everybody's pointing at somebody else. We're getting into that situation that when you do not have that dedicated team or that expertise in your business, all of a sudden everybody is pointing at someone else. So inevitably there's not an ownership or an accountability for a single person to get all of this completed. The second impact I think I'd probably add to that will vary by organization, but due to that kind of sophistication and growing side in the tech, what that means, it's not uncommon for many tech solutions to have multiple systems integrations and multiple APIs for data, reporting, automation, workflow management, multiple things. So depending, really on who owns those contractual relationships will also determine who is accountable in DORA for that very resilience and risk management that they're trying to report against. And so that may be the financial institution having a relationship with a business process outsourcer, but that BPO then actually may have very high levels of accountability for someone who's running their CCAT solution or their data management and so on and so forth. So it gets really, really complex.
Yeah, I think you're nearly giving me a headache listening to you when I think of all of the things that are intertwining there. But one of the key things that's coming across to me is the whole cost of compliance. And I don't mean in terms of obviously it's going to cost money, but it's also going to the expertise. And I'm going to come back to you, Luke, on this one. Do you think the relevant expertise is that they're going to need serious guidance to minimize the financial costs? Do you think that the legal sector is prepared to give the necessary guidance to all? And as you say, particularly from small firms, the bigger firms might have it in-house and are, historically better maybe. What about the smaller businesses who come within DORA's remit?
Yeah, I think that's a good question. Is the legal sector? I'd say we're ready. I don't know about the rest of the legal sector. Is for smaller businesses, are there sufficient resources there? Well, it depends on the approach you want to take. So there certainly is an approach you can take towards standardization and thinking about what you need to have in place before getting into some of the deeper, more difficult areas, which probably is more the realm of the larger systemic banks, etc. When they are providing regulated financial services to each other that have elements of technology to it, that's a major issue. That's something pretty deep. So they need deep expertise in relation to that. So of course they need external providers who can do that. From a technology provider perspective, I think there is a real need amongst the provider community to get support to understand what these requirements are, because the beginning of negotiations at the moment are different from previous rounds we've seen with EBA and EIOPA, etc., because there is a lack of understanding of how to match some of the specific DORA requirements, and if you look at the RTS as well, and the how against the practices of providers, and understanding shared risk perhaps from the bank and insurer's perspective, conveying that in a DORA specific requirement that needs some expertise. And I think that's a bit of a long way to say yes, there is a need to really look at this closely.
No, and to be fair, I suppose then coming to you, Mark, you're going to have to offer services that are going to ease that burden and try and, I won't quite say simplify, but you're going to have to reassure them that you meet those compliance requirements, but at the same time, you need to do it thoroughly enough to meet the requirements. I mean, how have you found the practical impact on trying to do this for people who need it done?
Yeah, so just being hands-on with the DORA register, it's making firms understand how connected they are to vendors and understanding where their weak spots are. if they're reliant on one vendor, what's the backups in place if that vendor or system goes down. Basically, the DORA regulation as a whole is getting firms up to understand their connectivity to these vendors, and how critical they are to the day-to-day running of critical functions in the bank. And it's getting them to delve into their third and fourth party risks to understand there. And really the real world example of CrowdStrike incident last year was a good one. Like that was a small obscure vendor, largely unheard of, and caused major disruption to Microsoft worldwide, across multiple industries. So DORA really is taking steps to have firms be prepared for this and to prevent or to work towards being more prepared for something like that happening in the future.
Yeah, and I have to. I don't think any firm wants that kind of notoriety, attached to them. That whole lack of security is very disconcerting for all consumers. They want to rest assured that, particularly if it's banks as opposed to even Microsoft, relatively speaking, is handling their money. And Paula, coming back to you then, what do you see as the questions or challenges raised by DORA? I mean, its intent is right. I think we'd all accept that. But is it meeting that intent in a way that's workable for those, particularly the chain of providers?
Listen, I think, when everybody shudders when we rehear again, Mark, CrowdStrike and Microsoft of July, we all think, oh, sure, we're filling in the paperwork. It's all good. We've got solid contracts with people. It's never going to happen. It's always okay until it's not okay. And that one absolutely rumbled right across the world at a massive scale. And I think that's the thing. Like right now, there's a lot of in 45 minutes already in this call, we've seen just how complex DORA is. Legislation in itself can feel scary to organizations because you want to be getting it right. The price of not getting it right is very high. But right now it's quite admin heavy. It's for organizations coming together and do a lot of administrative activity and sending these returns back. And that in itself leaves a risk. So just remembering that the work does not stop there, completing the forms, whether it's a register of information, be very careful that we don't start just paying lip service to legislation and completing the admin side, and really start to think about your business, about what does it mean to have audit ready returns, regardless of your current obligations under DORA. Even if you're small, where you're not necessarily having to complete that register of information. But I would encourage organizations to really implement governance and review proactively with their service providers and ensure that kind of resilience is monitored and is not that checkbox exercise. And training, that single point of contact is important, but this is a systemic change in what resilience and security is in organizations. So it's important that DORA training and awareness is right across the business, and that leaders of all levels and people, anyone who's really customer facing, has this culture whereby they feel safe to report if they see an issue and all of those other things that can happen. So it's not just a functional thing, it's a business-wide responsibility.
That's a really good point, actually, because a lot of people, if they are compliant with the legislation, think they have the box ticked. In other words, they're technically compliant, but they're not actually in the spirit of the legislation and making sure that they've actually, thought through the how they have responded and achieved compliance. So that I really like that point as a lawyer, as in it's nice to tick the box, but that's not enough. Luke, in terms of challenges you see in the legislation itself, and you mentioned whether there might be a DORA 2, or I don't know if you or Paul actually, but our Darren is probably quivering as he heard that, it being difficult enough to get DORA 1 off the line. What do you see as the challenges or questions that were raised by DORA that need to be addressed to make it achievable?
Yeah, I think all of us would have seen in the beginning it has been around classifying. I think Mark mentioned earlier, it's the help around what's a critical or important function and what services from third parties are provided for that. In the past, we're all familiar with outsourcing, but this extends beyond outsourcing. So also, the definition of services within scope of DORA is ICT services, so all digital and data services that are ongoing. So a lot of discussions around what is in scope, what's out of scope, and then understanding when should the more stringent controls for critical or important functions be provided to some of those what otherwise are not thought of as outsourcing providers. So data providers, they're very critical, but they're not outsourcing providers. What should be the controls applied to them? So a lot of discussion around that, or advice needed around that. And right down the supply chain, as we've also talked about. So the DORA itself doesn't, the level 1 text doesn't define an ICT subcontractor. So what is an ICT subcontractor? Those that effectively underpin the service. So there's a discussion about that. How, what do you do about those that don't effectively underpin the service? What controls have to be put in place? Some extensions around audit and access rights, not too much, but some extensions there. Take copies when on site, that can be an issue for some. And then this training requirement that Paula asked for. So that's something new, particularly in a non-critical environment. Need to ensure that suppliers engage in training. And what Darren mentioned earlier, the threat-led penetration testing regime in specific contexts as well. So how practically, again, how is that going to work? How are you going to get your suppliers involved? So yeah, so a range of issues there. I mean, I could go on. There's many.
No, that's probably plenty for them to be going on with. But one key one, I think, as a starting point, is you say the potential lack of clarity about who's within its scope. Because to be fair to everybody, I mean, they need to know whether they're bound by it or not. So I am going to come back to you on that, Darren. The lack of definition, or the lack of definition for everything, as Luke has mentioned, is that something that you're likely to address?
Sorry, everything's a little bit broad there for me.
Fair enough.
Would you like me to answer the questions or answer that question specifically first? I'm sorry, taking notes.
Oh yeah, no, that's fair enough. Well, sure. Maybe start with that question and then do the
and get back to. All right. Okay.
Notes. Okay.
Okay. On the timing, which was Luke's first point, he's exactly right. But the fact is, the legislature did not envisage a transition period. So according to the law, DORA came into application 17th of January, and admittedly, there were a couple of regulatory products still to be adopted and published. And the main two outstanding still, although I think, as you said, it's fairly clear what they'll be, is on the subcontracting and the threat-led penetration testing. However, we did an industry event last November. It's recorded. I'd commend you to have a look at that, especially a speech by Jerry Cross, who's one of the directors here at the Central Bank, where he talked. As I said, the supervisory authorities are required to enforce the law, but he did talk to the concept of, an initial compliance and then a deepening compliance over time. And this, even though there isn't a transition period in the legal application, to me, one of the most important bits in DORA is the learning and evolving. And over time, norms, I hope, will develop that will make all of this very easy. The first time doing all these things is very hard. But as I said, I hope over time that the intended outcomes of DORA, which is that we have a safer financial system, are actually achieved. To the next point from Paula on the expertise, you're exactly correct in terms of there are going to be pinch points with expertise. We're highly aware that from our own experience on the Cyber IE framework, for instance, the number of red team testers that are at the skill level that you need to do an effective threat-led penetration test are very, very limited. And again, norm over time, I would hope that, and in general, cybersecurity expertise, is in high demand, as are all IT skills, and indeed other areas of the business. But as these become norms, I think two things happen. It will be seen as a skill set people will want to develop into, but also certain things will get easier, hopefully, which leads also onto your point on who's accountable. One of the areas where DORA is really trying to push the envelope, in my opinion, is on the third party relationships. If you think of, if you're dealing with the telecoms provider, getting a phone line interest, I know nobody does that anymore, but you didn't have a lot of say on the contractual agreement. And some of these things, especially for small players, are very hard to achieve. But the intention here is that if everybody requires it, then the providers have to respond. We did actually see this happening. Luke, you mentioned the previous EBA outsourcing guidelines, and what we saw there was initial really strong resistance to the very idea of right to audit, but eventually realizing that is the way things are going to go. I think there was generally agreement with it, but then a request to be audited in a pooled fashion and not have, if I'm a big provider, I don't want a different firm coming and auditing me every day of the week. Do it as a pool, and yeah, I'm hoping to see more, say, publication of the subcontracting chains, readily to the people you're providing services to. And the IT industry, in fairness, has been quite opaque. The systems are complex. You don't ask what's under the hood. You're not told. DORA is looking to push that because, it's not okay, to be responsible for the system and your customers and your partners and not be taken care. So on the point on complexity, absolutely. In fact, as well as the CrowdStrike, there have been a couple of high-profile incidents with middleware that people maybe weren't even aware that they were reliant on a third party for that. So those chains, absolutely, it will be hard. But over time, hopefully, we will see the risks and the impact of incidents reduce. And when things go wrong, that firms will already know that they have a substitute or provider over here that they can move to quickly, and have what they need to do that. As an example of a type of situation. In terms of small businesses, great point, which is DORA, it has proportionality built into it. Yeah. If you're a big, huge bank, you have to do all of DORA in all its complexity. Everybody else, it's subject to proportionality, nature, scale, complexity. And in some of the technical standards, they even talk about elements of increased or reduced risk, that can be present. And what does that mean in practice? I don't know. Over time, we'll see what good looks like. But right now, it's up to individual firms to look at that, see their operations, see what the risks are, and ensure they're responding proportionately in line with DORA. So certainly on the risk management framework, that chapter, a lot of proportionality in there, but it'll take time for us to have, a common sense of what's good enough. Mark, to your point on identification of weak spots, and absolutely, I think that's what's intended. I know there were concerns in industry about even just the level of notifications you might get from a big third-party provider. But again, I hope norms develop where you can publish a list, and everybody, that kind of communication becomes normal to say, this is who we're using, this is where your data is going, this is who has access to it, and this is how we protect it. And we will indeed let you know when there's a big incident, because that absolutely was an issue prior to DORA as well. And
well, you've done exceedingly well, as they would say, but keep going.
Yeah, I think I've rounded right back to you, Brona, and I think your point was really down to definitions, and I came from the IT into this policy stuff, and the law is a big animal, and definitions count. And in DORA, there are a lot of big words used, like all. There were all network connections, supporting, and Luke talked about the fact that the ESAs themselves tried to help out by pointing in the register to the subcontractors that effectively underpin the service, to try and narrow that down to something that's realistic in terms of what has to go into the register. There is, I think, for some time we'll continue to see Q&As. The ESAs maintain a joint question and answer database. If you go to the EBA, ESMA, or IOPA, type in joint Q&A or Google on them, and you'll get to it. And what you'll see is there continues to be questions coming in that are trying to effectively understand that. It's within the purview of the Commission to interpret the level 1 text. And then in terms of how it should be applied, again, with the view to try and get that harmonized, it's up to the ESAs there. So that Q&A is something we look to going forward. And there have been efforts, certainly on the terms like the ICT third-party providers. There's a Q&A 030 specifically tries to tie that down with a bit more clarity. Also, just on the point of harmonization, sorry, but essentially I'm acknowledging that there are challenges in some of the wordings.
No, and to be fair to you, Darren, I have to say your whole presentation has been very receptive, as opposed to, that this is a done thing, this is the way it is, that it's a new, and that you'll accept that people, well, I'm getting the sense that people who will be doing their best to adhere to it, they will be, entertained or, given the benefit of that.
I think the point that financial entities maybe don't understand is it's new for us as well. We're establishing those norms. What I expect to see is that over time, if there are specific pain points, there will be guidelines coming, provided to address those as we learn how to be done. There are some things that are very clear requirements in DORA, and I'm not saying that they can be passed over willy-nilly, but there are a number of elements where there's an element of judgment, and I know our own Deputy Governor had a speech last week where she specifically spoke to how, as a regulator, we've limited resource too, and we're very outcomes focused. We try to be future looking, that we're judgment led, and we do risk based supervision. But actually, it's up to financial entities themselves. This is about financial entities looking at the risks they're exposed to and prudentially, managing them. So there is a lot of judgment has to be done on the part of financial entities. And there's areas like even identifying what critical and important functions are. DORA doesn't specify methodology to do that. But if you look at, for instance, we've guidance previously published on outsourcing, where we recommend that you at least write down what your methodology is, apply it the same everywhere, and you've something to stand on when we come to talk to you. You can say, look, this is how we approach it. This is how we've decided that is or isn't critical or important, and hence why we have or haven't done controls. And lastly, to acknowledge Mark as well on the large banks. Actually, some of the elements in DORA are easier for small entities, although that doesn't say even the regulation itself is quite large. Just to get your head around it, agreed. I'm going to stop talking at that, Brona.
Well, you've done very well, and to be fair, I think you made a salutary reminder at the end that legislation tends to set the minimum standards for people to protect themselves. So it's actually in everybody's interest to have all these systems in place, and they're only, I suppose, made obligatory to protect consumers or people in the end line who don't have those protections. So I think you've presented a very fair case on behalf of the central bank. It's not necessarily any less daunting for those who are going to be striving to comply with it, but at least that kind of open door policy is also refreshing to hear that people, if they have concerns, can, as you say, go to the Q&A or make representations to see about things being changed. We're over time just by 3 minutes. Sorry. But to be fair to all of you, I think it's a topic that probably merits, it's complex and deep enough that you could talk about it for another couple of hours. But it has been a great overview. So my sincere thanks to Darren for making the presentation, but also to Paula, Luke and Mark. To be fair, your contributions have made his presentation real in terms of that's what has to happen in the legislation. It has to work in real life. And it is certainly, from my perspective, it's been very interesting. So thank you all very much. And to our audience who are listening, equally, thank you for your attention. And I hope you all got something out of it. You know who all of these persons are. So if you need any guidance in their particular roles, I'm sure I can offer their service. You feel free to make contact. And the RegTech Supercluster, to finish on that, I mean, again, this is one of those areas which are core to our interest in terms of facilitating the dissemination of knowledge. And if there are people in the audience who are interested in getting involved in that, again, reach out and LinkedIn or via our website. But thank you all very much, and I hope you enjoyed it as much as I did. All right, cheers. I'll formally end the event then.
Thank you.
Thank you.